Hello, everyone. My name is Natalie Scott, and thank you so much for engaging in today's presentation. I am MCASA's Sexual Assault Response Team and Sexual Assault Forensic Exam Policy Advocate, also known as SART Policy Advocate. We're going to go through the different roles of the individuals who sit on sexual assault response teams in various presentations, and then we will go into a panel in which individuals who take on these roles in sexual assault response teams can answer some questions about their role and how they work with advocates. If at any point you have any questions about these presentations, you can feel free to drop them in the chat. I will periodically check those as well. And to start off, I'm going to be presenting on the role of the forensic nurse examiner, also known as the FNE. If you have any questions, as I said, that come up, please feel free to drop them in the chat. And if I don't answer them right away, just because I'm sharing my screen, I'll answer them once I conclude. So to start out, what is a SAFE? We're going to discuss what exactly a SAFE is. So a SAFE stands for Sexual Assault Forensic Exam, and it's a procedure that provides survivors with important medical care and allows for the collection and preservation of potential evidence from an assault. I find the easiest way to break down and understand a SAFE is to separate it into two parts: evidence collection and medical attention. So the medical attention portion includes elements such as checking and treating for potential injuries. Also, it includes providing STI prevention, treatment, or testing. And then finally, it provides pregnancy prevention. So, for example, providing emergency contraception pills like Plan B to survivors. The evidence collection portion includes taking photos of injuries, collection of DNA, and collection of clothing items. It's important to note that new laws state that SAFEs conducted up to 15 days after an assault occurred will be reimbursed. And this law does not specifically state that only cervical swabs should be collected when a victim presents more than 5 days after an assault. So in Maryland, you can receive a SAFE up to 15 days after a sexual assault has occurred. And that varies state to state, but in Maryland, it's 15 days. When thinking about options for survivors and when understanding the process of receiving a SAFE and reporting assaults, it's important to understand the different options that survivors have. So survivors do have a variety of options when choosing to report a sexual assault, either to the emergency department, law enforcement, or to a rape crisis center advocate. Survivors reporting to the emergency department may choose not to receive the SAFE and simply just receive medical treatment. If they choose not to receive a SAFE, advocate presence should still be offered as they are still a survivor of sexual assault. I also want to highlight that Child Protective Services and Adult Protective Services are called in cases that involve child sexual abuse or cases that involve vulnerable adults. And so when I was first learning about this, I wanted to develop a better understanding of who was considered a vulnerable adult. So vulnerable adults, according to Maryland's Office of the Attorney General, are people over the age of 18 who lack physical or mental capacity to provide for their daily needs. So now to discuss advocacy. Advocates are available to survivors before, during, and after any portion of the sexual assault forensic exam, including in the exam room. Before an exam, advocates can work to address acute concerns identified by the survivor, work through any questions about the exam process, explain their role in services, and review potential reporting options. It's important to be aware of what to do when you are in the exam, or I'm sorry, During the exam, advocates can help support the survivor through any and all parts of the exam. So, including offering grounding strategies, co-regulating, offering encouragement, and empowering the survivor to choose from the menu of exam options. So now that we understand, the role that they play in the exam room, it's important to be aware, as an advocate, what you do in the exam room. So, for example, don't speak for the survivor and don't touch nursing tools. It's overall important to just understand your physical space in the room itself. It's also important to be prepared to ask the survivor if they would like privacy or for you to stay during various parts of the exam. So, for example, some survivors want your physical presence during the narrative portion of the exam, but may request privacy during a speculum exam or evidence collection. After the exam, advocates can work on safety planning for the post-crisis intervention period. So the SAFE hospital should have a protocol in place in which an advocate is immediately notified when a survivor presents to the emergency department. Advocates can work with FNEs or forensic nurse examiners and potentially law enforcement to ensure a timely survivor-centered coordinated response to the hospital. Another important note, a survivor may choose to have an advocate at the hospital, even if they choose not to have a SAFE completed. So as I highlighted earlier, if they just want to receive medical attention and not have a SAFE, they still should have that advocate presence offered. Survivors are not required to have an advocate present and may choose not to on the flip side of this. So in this situation, an advocate can provide contact information or relevant community referrals to the survivor to reach out to if they want to in the future. So now just what occurs during a sexual assault forensic exam, and kind of go into depth of what this exam means. So the SAFE exam includes several important elements, including a detailed interview by an FNE, a body exam, evidence collection, photographs, and a documentation of findings. It's important to note that a survivor can choose not to receive any portion of the exam at any time. During the interview, survivors can disclose what they choose about the assault. However, an advocate can gently encourage details as it will impact medical prescriptions and evidence collection. The exam can last anywhere between 3 to 6 hours. During the exam, the FNE will look for bruising, wounds, and other injuries that may have occurred during the sexual assault. If any injuries are present, the FNE will use photos to document the wounded areas, and you can see some examples of that on the slide. There are also cases where injuries are not visible. So, for example, in strangulation cases, in these instances, an alternate light source may be used to photograph areas. An alternate light source is a technique that can detect bruising or injury that has occurred beneath the skin layer and is not available to the naked eye. Another part that I want to highlight is swabbing. So a forensic nurse will use cotton swabs to collect evidence inside the mouth and under the fingernails. A genital and anal exam are also completed in which a forensic nurse conducts both internal and external swabs on the area. Especially, can you all hear it? How do I look? Is now okay? Okay, I'm going to leave and then reconnect in a moment.
Rachel, I think ASL interpreters, can you hear me while I'm speaking? Okay, thanks. So it looks like Natalie is leaving and coming back because of some Wi-Fi issues. So we'll give her a minute. Um, but I believe she was talking about swabbing. So just important to remember with swabbing that survivors can have any part of their body swabbed. So really framing it for survivors as a menu of options, meaning that they can decline or accept any part of their body being swabbed, whether that's internal and external. When I'm working with survivors, I'll often explain it to them as like a very long Q-tip that's just moving against their body. Sometimes folks have difficulty with the sensory experience there. But really reminding survivors that that evidence piece collection is their choice and not at all required. But it looks like Natalie is still struggling a little bit with Wi-Fi. So if it's okay with the group, I am going to share my screen and move on to the role of law enforcement. Right. So Natalie was covering the role of the forensic nurse. I am going to cover the role of law enforcement and victim advocates' engagement with law enforcement. My name is Grace Rupp. I am MCASA's Sexual Assault Response Team and Prison Rape Elimination Act Policy Specialist. So today, I'm just going to quickly review how law enforcement receives and responds to reports of sexual assault. I'm going to review how, the role of law enforcement during an interview, during an investigation, and any sort of evidence collection. And then hopefully we'll all understand the roles of victim advocates during the investigation and when working with law enforcement. Right. So how does a survivor connect with law enforcement? There are a few different ways when considering different reporting methods. So there are a few ways that law enforcement would initially receive their report of sexual violence. The first is through hospital personnel. So when a survivor reports to a sexual assault forensic exam program, they are given the option from hospital staff to inform law enforcement, but they are not at all obligated to. So their medical care is not contingent upon reporting. If a survivor would like to involve law enforcement, the hospital personnel will contact local law enforcement and they will respond to the hospital itself. This does require explicit and ongoing consent from the survivor. So you'll also see law enforcement receive reports from survivors directly or themselves. They may immediately report the assaults. They may report it after, for some cases of intimate partner violence or domestic violence. You may even see survivors reach out to law enforcement while violence is occurring. But just an important caveat that delayed report can be any sort of time span. So whether that's a day, a week, a month, years after the assaults, law enforcement typically would consider that a delayed report. You'll also see law enforcement receive third-party reports. So somebody who's witnessing the violence may report and make that initial call. In most cases, when this happens, it's the patrol officer that's the first responder. And then they determine that what's going on is sexual violence or domestic violence. And then a detective is typically called to the scene. So there are many different ways law enforcement might receive a report. And then from there, they'll work on that response piece. So what are the responsibilities of law enforcement once they receive a report? So that initial response is really important, right? It lays the groundwork for future interactions with survivors. This is a really important opportunity to start to build rapport and trust with the survivor. It's important, right, that initially law enforcement officers are trying to make that initial determination on what happened. So typically they'll describe this as the minimal facts interview. So really just the when, where, what sort of questions. From there, this often means, right, they're making assessments for safety and the survivor's needs. So they're usually assessing for emergency medical care and helping a survivor determine whether a safe is something that is necessary for their physical safety and or something that a survivor wants to engage in. Important to remember here that survivors can receive a safe up to 15 days post-assault. That is unique to Maryland. Not every state has that time window. Additionally, that initial response includes collecting information to help identify and locate a suspect. We're trying to get some of that where information. So the location of this assault, the time. So they're seeking that basic information to help identify the needs of the survivor, secure the scene, identify the suspect, and work to establish elements of a crime. Identifying and locating the subject also helps support public safety, ensuring that the wider community is safe. At this point in the preliminary investigation, responding officers and deputies typically have to decide whether they're going to make an immediate arrest for the suspect. This decision will need to be made based on factors like probable cause, whether an immediate arrest is necessary to secure the safety of the wider community, if there are vulnerable adults or children involved, things like that. But that initial response is really about securing the safety of the survivor, the public, and the crime scene. So their main responsibilities lie in three key areas: protecting and supporting the victim, gathering preliminary information, and then protecting the crime scene, maybe scenes, and collecting evidence related to the case. It's important that when law enforcement is doing this work, they're being trauma informed, meaning that they can include a victim advocate and should in this process. Most law enforcement agencies in Maryland work with their local rape crisis centers who can provide support beyond just that initial investigation. Other tasks that law enforcement and advocates can do together, working on things like safety planning, addressing other needs, so whether that's housing, childcare, supporting survivors in seeking a safe. But law enforcement can really use the Rape Crisis Center to connect survivors to other types of support that are outside the scope of their practice. All investigators should be trained on trauma-informed interviewing techniques. You'll hear Natalie and I on Thursday talk about the neurobiology of trauma. But law enforcement should be aware of trauma symptoms and how that may impact a survivor's behavior and ability to recall information. Gathering initial information and details can be really challenging given survivors' issues, oftentimes with chronological recall and executive functioning. Law enforcement right, should be aware that there's no correct emotion or correct way to respond when sexual violence occurs. So these three key responsibilities are really within the initial response. What does an investigation look like for law enforcement? So first and foremost, right, law enforcement is prioritizing the safety of the victim and any sort of family or loved ones that might be involved. So they're looking into whether the perpetrator is a known person or maybe a stranger. And that's going to include asking the survivor for details. As a victim advocate, you might be present for some of these questions. Some of these questions might sound like they're victim blaming, right? So for example, a law enforcement officer might ask something like, at the time of the assault, do you remember what they're wearing? As a victim advocate, it's helpful and important to be able to translate some of these questions for a survivor. So being able to contextualize the why behind that question. So saying things like, officer is asking you this so he can ensure that evidence is collected in an appropriate way. He's not trying to blame you for what you were wearing at the time. So providing background and context for survivors can help avoid that re-traumatization. Oftentimes law enforcement officers are willing and able to do that themselves, but it can be helpful as a victim advocate to have that skill set. Law enforcement is also responsible for conducting a thorough criminal investigation, right? Continuing to determine where the perpetrator is. Do we know the perpetrator, right? Grounding safety in that. Determining if a weapon was used. Additionally, this is where you'll see law enforcement ask some of those more specific questions of a survivor. These details, while often really challenging for folks to discuss and engage in dialogue around, are essential to criminal prosecutions and investigations. All of these details, law enforcement is and are using, right, to determine the ability for search and seizure warrants. You'll also see in the investigation process, right, this is not a one and done event. It often spans weeks or even months. So after that initial determination of safety and ongoing engagement with safety, you'll also see law enforcement maybe interview witnesses. They will work to test, store, retain the sexual assault evidence kit that the survivor got at the hospital, working through the forensic analysis of that kit, and then making that determination. So moving on to the types of evidence you might see in an investigation. There are various types of evidence that law enforcement might be looking for in their investigation. The first, Natalie mentioned, a sexual assault evidence kit, usually conducted at a safe hospital. The survivor has the right to a free safe exam up to 15 days post-assault. Law enforcement does store those kits along with other evidence from the crime scene. These things are all helpful in starting to build that investigation and that case. You might also see other materials from the scene being collected, things like sheets, pillowcases, blankets. You might also see victims' clothing, whether that's undergarments or what they were wearing at the assault. Or during the time of the assault, forgive me. Additionally, if there's any bodily fluid, things like condoms, any sort of cell phone communication can be documented, digital images, or any sort of interactions online. Regardless of the type of evidence, It is law enforcement's responsibility to safeguard items of evidentiary value in accordance with Maryland law and best practices. So in Maryland, sexual assault evidence kits are stored for 75 years. This is, of course, not the be-all, end-all list of possible evidence being collected, but it's just some that you might see law enforcement look for. Details provided by the offender, the survivor, witnesses may also inform the evidence collected that law enforcement is charged with safeguarding. So just to close out a little bit around anonymous reporting. So survivors have the right to report to law enforcement, but they also have the right to not report to law enforcement. So they have the ability to have their sexual assault evidence kit collected, but not report to law enforcement. So this means that there's no official police report. However, the kit itself will be stored with law enforcement. Within that, though, there's no personally identifying information on an anonymous kit. In Maryland, anonymous kits are held for 75 years. And in that time span, survivor can choose to report. So survivor can go from an anonymous kit to a reported assault. If a survivor chooses to report at that time, law enforcement would open the kit, gather information, and begin that investigation. Until then, the kit is simply stored with no personally identifying information and then destroyed in accordance with Maryland law. Within that, though, anonymous reporting allows survivors to receive medical care and store evidence without having to report to law enforcement immediately. The window of tolerance, the window of reporting, again, is that 15 days. So this gives survivors the option to preserve evidence without having to engage with law enforcement. Oftentimes, this gives survivors space to process and recover from their assaults prior to engaging with law enforcement. And at any time, they can convert their report from anonymous to reported. Oftentimes, this is helpful in keeping victims from dropping out of the criminal justice system altogether, which can happen if people report when they're not ready to engage with that system. Remembering here that as a victim advocate, one of your roles is explaining to survivors their options, including the option to report anonymously. Remembering here that this is the survivor's decision. We don't want to incorporate our personal opinion into our engagement with them. So letting them know that it's okay not to report immediately. It's an option for them. It's okay to get evidence collected. It's okay not to get evidence collected. Really, as an advocate, it's our job to encourage them to do what's best for them and helping them in making an informed decision. So lastly, how can advocates support survivors while working with law enforcement? What's our job in interacting here? Where do we come into the picture? So first and foremost, we are there for the survivor. So in engaging with law enforcement, remembering that we work for the survivor, not for law enforcement. So if you are involved in that investigation process or that interview process, remembering first grounding safety, right? So we want to ask and have specific questions and those crisis intervention skills around what a survivor needs. So asking them directly, do you need a break? Do you need water? Do you need a safe place to stay? Really partializing their needs. So letting the survivor identify what's most urgent to them and then going from there. Advocates often provide support to victims during an exam or an interview. Really, here we're working on being a grounding and calming presence, checking in with the survivor's emotional state, providing that reassurance and validation, and then making sure that we're always foregrounding safety in our work. Again, this is where intentional referrals can be really helpful. So whether that's to the Sexual Assault Legal Institute, whether that's helping support survivors in getting a forensic exam, supporting a survivor through a forensic exam like Natalie mentioned, but making sure that survivors are aware of all of their options and making those informed decisions. So again, we're working on providing that emotional support, advocating for the survivor's stated wishes, working through that safety piece. Maybe that's specifically working through safety planning, and then helping with named and intentional referrals. So Rape Crisis Center advocates are often really excellent at having those micro referrals that are really geographically and identity specific for survivors. And then just some things to think about avoiding, right? So when working with survivors, especially survivors who have decided to report, it's not our job to encourage or discourage survivors from including law enforcement in the reporting process. We all have different, opinions, thoughts on the criminal justice system and working with law enforcement. And we might have strong feelings about whether survivors should or should not report. It's really essential to keep those opinions out of any conversation you have with a survivor, as it might directly impact the decisions they make. Again, not all survivors want to go through with any sort of investigation or police process. Some survivors, they will ask questions like, what would you do if you were in my shoes? If you've been assaulted, if you were assaulted and you reported. It's important to answer this question in a way that highlights their needs, not our past experiences. So if you're asked something like this, you can say something like, I'm here to support you right now, or I think it's really important that we focus on what you need, or saying something like, every individual is different, every person is different. Although it might be helpful to hear what others have done, we want to focus on supporting you through making a decision that works for you. Additionally, what we know about trauma, we don't want to interview the survivor. It's not our job to investigate. It's not our job to ask those sort of W questions. That's the role of law enforcement, and really letting law enforcement lead the way in that process. If you feel like survivors are having a hard time understanding a question, you can ask the other providers to maybe say it in a different way or ask in a different way, but really making sure that survivors understand what's being asked of them. And then lastly, we can't make promises in this process, and we want to avoid saying things that we cannot ensure with 100% certainty. So don't say things like the police will get them, they'll go to jail, the evidence will come back and DNA will be found, right? We don't know those things with 100% certainty, so don't say them to survivors. Additionally, not all survivors have the same view of the criminal justice system. Not all cases, in fact, we know many to most cases, don't get solved or result in convictions. And the suspect may not get arrested. And even if they are arrested, right, they may not stay in jail. The survivor may not want them in jail. So really avoiding that sort of commentary around our opinion of the criminal justice system. So just in summary, recognizing that not all survivors will respond to sexual violence the same way. Not all survivors will want to report the assault to law enforcement. When working with law enforcement and survivors at the same time, we want to focus on the survivor's needs and really allow law enforcement to do that investigatory work. So supporting the survivor through the investigation process is often focused on foregrounding safety, making those intentional referrals in the moment, and providing that calming and grounding presence during crisis intervention. Again, regardless of where we are in this process, we never want to speak for the survivor. And then really thinking about making those local resources and referrals that are intentional and named by the survivor. Lastly, we want to make sure that we know and can articulate in ways that can be understood by all our reporting and confidentiality requirements. So if, all adults in Maryland are mandated reporting, being able to articulate what your mandated reporting requirements are, knowing the limits to your confidentiality, when you would have to report certain things, being able to articulate that to survivors. All right, so here's my contact information. You are welcome to reach out to me. I'm going to stay throughout the presentation to answer any questions. Thank you all so much.
Thank you, Grace. I believe we are going to jump into my presentation. I'm going to try to share my screen. Everybody, please let me know if there are any issues with that. Can you all see my screen now?
Yes, we can see it.
Fantastic. So my name is Carrie Tyrrell, and I am the Legal Services Director here at the Sexual Assault Legal Institute, or SALI for short. I'm here today to talk to you about the role of the prosecutor. And part of why I've been selected to talk to you about this is I am a former prosecutor. I worked for 4 years in the Brooklyn, New York District Attorney's Office. Specifically, I worked in their domestic violence and special victims bureaus. I have never done general prosecution. So my background is very specifically in this field, and I'm happy to be talking to you today about the role of the prosecutor. So let's start by talking a little bit about who prosecutors are. Prosecutors are attorneys who represent the whole state or country. They don't represent individual survivors. Why is this so important in the legal sphere? Attorneys, generally speaking, have what's called attorney-client privilege. And that means that anything that their clients tell them, pretty much unless it's I'm about to imminently commit a crime, they have to keep to themselves. They can't disclose to someone else. There are some exceptions for fraud and various other things, but it has to be really, really egregious. That's not the case with prosecutors. There's no attorney-client privilege and not even confidentiality in Maryland. Additionally, prosecutors have, and we'll discuss this a little bit more later in the slide if we have time, certain constitutional obligations under a case called Brady and other discovery obligations, meaning generally speaking, what survivors or other witnesses tell them, they're going to have to tell the court and they're going to have to tell defense attorneys. Prosecutors' offices throughout the state and country go by a lot of different names, and this can sometimes confuse our clients. In Maryland, the prosecutors' offices are called state's attorney's offices. There is one state's attorney for every Maryland jurisdiction, every county and Baltimore City. That person is elected. You all, if you're Maryland residents, vote on your state's attorney. The lawyers who go to court on behalf of the state are called assistant state's attorneys, or ASAs for short. This can also be confusing. Sometimes I've had some survivors be upset. They don't want to talk to an assistant. And so it's important to understand that the assistant really is the attorney who is going to be going to court and making a lot of these decisions. So what do prosecutors do? They run criminal cases for the state. So they decide if someone gets charged, what crimes get charged, whether to offer a plea bargain or to go to trial, and if there is going to be a plea bargain, what plea bargain to offer, what evidence to put on at trial, and what sentence they would argue for after conviction if the case does go to trial and result in a conviction. So who gets charged with a crime? As we talked about, it's up to the state's attorney because they have something called prosecutorial discretion. The quote below comes from a United States Supreme Court case, so the highest court in the land, and it's about prosecutorial discretion. It says, so long as the prosecutor has probable cause to believe that the accused committed an offense defined by statute, the decision whether or not to prosecute and what charge to file or bring before a grand jury generally rests entirely in the prosecutor's discretion. What's key here is that that's not the survivor's discretion, that's the prosecutor's discretion. So how do prosecutors evaluate cases? They're looking to see what is the crime. If you look at various laws, I almost like to describe it as a cookbook. You need certain ingredients in a cookbook, and then you do certain things, and you have your product. When you're looking at criminal laws, they require certain actions and certain mental states. Those actions may include being of a certain age for some of these sex crimes or not being of a certain age. These are all things that they're going to look at to try to match the actions that were committed to a law that was passed by the legislature. Then they also have to consider what the evidence is. And we'll talk about the various burdens of proof a little later on, but they're going to be looking to try to see if there's going to be enough evidence to conclude a case, not just whether they can bring it in the first place, but what's likely to happen further on. They're also going to, and that will be the standard of beyond a reasonable doubt. That's the standard at trial. They may also consider the objective in bringing these charges. Is the objective going to be to hold that particular perpetrator accountable, to hold perpetrators more largely accountable, send some kind of message? And they may be considering facts about the perpetrator as well. So if we were talking about a drug-related case, they might be considering whether this person has an addiction problem and are they best served with criminal charges and certain kinds of criminal outcomes, or would they be best served by some kind of other intervention, some kind of rehab program or something of that sort. So as we discussed a few slides ago, the standard to bring a case in the first place is something called probable cause. And the standard at trial is something called beyond a reasonable doubt. These are vastly different standards. Probable cause requires sufficient reason based on known facts to believe that a crime has been committed or that certain property is connected with a crime and that the person who is being charged is connected with that crime. And sometimes that can be harder. This is a stranger case. Probable cause is required to charge someone with a crime. Without that, technically, they would be acting unlawfully. Beyond a reasonable doubt is part of the jury instructions in criminal trials. While they're called jury instructions, the judge would also be expected to follow these instructions if the case were tried to a judge rather than a jury. And we might have a chance to talk about that a little bit more later on. They are told that they can only find the defendant guilty if they are convinced, quote, beyond a reasonable doubt of his or her guilt. So that's a very, very high burden. So, as we discussed, in deciding what crimes to charge, they have to look at whether the conduct alleged satisfies all of the elements, any kind of action requirements, any kind of mental requirements. And one action might make out all of the elements of a whole bunch of different crimes. For example, assault in the second degree under the criminal law in Maryland requires an unconsented to and offensive touching. Sexual offense in the fourth degree also requires similar things, but requires that it be done for a sexual purpose or with the intention to abuse or for sexual gratification. So the same touching, and it would have to be of an intimate area. So if someone were to grab someone else's, say, butt on a street corner, that would be most likely both a sexual offense in the fourth degree and an assault in the second degree. So you can see a lot of different charges listed for one act. Those are both misdemeanor examples I just gave you, but there are felonies as well. And in Maryland, misdemeanors have statutes of limitations. They vary sometimes by misdemeanor, but felonies do not. What does that mean? What is a statute of limitation? A statute of limitation is how long someone has to bring a particular case to court. Unfortunately, misdemeanor cases in Maryland, most of them cannot be brought beyond a certain period of time, and generally that is 1 year, but there are exceptions, so it's important to be aware of that. So I've talked a lot about this in the abstract, but let's look at a specific example. We're going to look at harassment, which is defined in Maryland criminal law 3-803. This is the law that the legislature passed, and that's the law that the prosecutors have to work with in Maryland. For our purposes, we're going to focus on section A and B. So A says a person may not follow another in or about a public place or maliciously engage in a course of conduct that alarms or seriously annoys the other. 1, with the intent to harass, alarm, or annoy the other. 2, after receiving a reasonable warning or request to stop by or on behalf of the other. And 3, without a legal purpose. Exception B. This section does not apply to a peaceable activity intended to express a political view or provide information to others. So when assessing whether someone has committed harassment, one of the things that prosecutors would be looking at is whether there was a legal purpose for the conduct. We see this come up sometimes in child custody or child support cases, where the perpetrator may say, the legal purpose of me sending her 80 text messages and calling her 200 times was to facilitate the drop-off or the pickup of this child. I have a court order that says we're supposed to exchange custody. We're supposed to communicate about the child. Sometimes that may unfortunately make this harder. Another thing that a prosecutor is going to look at is whether a perpetrator kept having this type of contact after being told to stop doing it. And I've seen that come up in court, but there does have to be this request to stop. And this isn't things that the prosecutor is coming up with, that the prosecutor is saying, yes, I love this law. This is exactly how I'd write it. It's what the current law is, and the only way they can charge is if what someone is doing matches a current law. So let's talk now about evidence. I believe Grace touched on some of these things, so I won't spend too much time talking about it. But what I really want to focus on is that a lot of things that in our day-to-day life we might consider in determining whether or not something has occurred or who we believe might not be admissible in court. In court, rumors, for example, are not admissible. Hearsay, someone saying that someone else told them something, is often not allowed. Usually you have to have the person who was directly there and witnessed that thing testify. There are some exceptions, but that can be very challenging if, for example, you're working with a survivor who says, everyone knew that John Doe is a womanizer. Everyone knew that he encouraged women to drink too much. Well, who knew this and how did they know this? Cannot be brought into court. There are other reasons that some of that information may not be allowed in court as well. There are certain protections about prior bad acts and character evidence. We won't go too far into any of that, but it is just important to know that some things may be admissible and some may not. However, it's good to tell the prosecutor about everything because they may be able to take that rumor and investigate it a little bit more. Okay, so you've heard that John Doe is encouraging women to keep drinking or buying drinks for women and handling them at bars. Who told you this? How do they know this? And that might lead to more admissible evidence. We talked a little bit earlier about some outcomes short of a trial. Very few criminal cases go all the way to trial. Most cases result in what's called a plea bargain. And that is where the defendant might plead guilty to a lesser offense, one of many charges, or even to the top charge, but agree to a lesser sentence to avoid the risk of trial. Obviously, some pros of this is it saves the survivor from having to testify and there's certainty about what's going to happen. The biggest con is that a survivor may not agree with the offer. They may not like what the state's attorney's office decides to do with the case. Unfortunately, that is ultimately the state's attorney's office's decision once they consider the laws, the elements, and the evidence. Another possibility is that charges may occasionally have to be dropped. There may not be enough evidence. Some new exonerating evidence may come to light. They may be able to provide some kind of alibi notice that the prosecutor doesn't think that they're going to be able to get past. Some witnesses may stop cooperating or may not be available. Maybe they leave the state. Maybe, unfortunately, they pass away or something of that sort. However, as of October 1st, 2023, a prosecutor is legally required to explain why they are not bringing charges if a sexual assault survivor requests a meeting about this. If you do have survivors who are interested in this meeting, this is something else that we at the Sexual Assault Legal Institute can help facilitate. I think sometimes people don't reach out to us once a criminal case is dropped because it's over. And while we can't force the prosecutor to move forward with charges, if they do want some closure, some more understanding about why this happened, why charges weren't brought, that is a thing that we can help them get at that meeting. So trial involves a whole bunch of different things. It involves voir dire, which is when a jury is selected. The survivor would not be present for that. Opening statements by defense and by prosecution. Again, anybody who's testifying probably should not and cannot be present for that. Why? Because then there's this ability to argue that whoever listened could be tailoring their testimony to match. The defendant will be present, and most likely the prosecutor is going to bring that up if they do choose to testify. After opening statements, it's the prosecution's case. This would include the victim's testimony. That's when they get direct questions by the prosecutor, those broad, open-ended questions, and cross-examination by the defense attorney. Cross-examination can be very difficult. Isn't it true that, and then whatever it may be, they'll try to make any small discrepancies look big. After that, there's usually something called a motion for judgment of acquittal. That's the defense attorney arguing that legally the elements of the crime were not shown, that something was missing. Remember when we were talking about all the pieces? So maybe someone gets charged with a sexual offense in the 4th degree and an assault in the 2nd degree. And at that point, the defense attorney tries to argue it wasn't an intimate area that was touched, or that the purpose was not for sexual gratification or abuse. Most of the time, motions for judgments of acquittal are denied because prosecutors have already thought about these elements and how to prove them. But it's something that every defense attorney is just going to do as a matter of course. It's something that they're expected to do. The defense then has an opportunity to put on a case. They do not have to. They can choose not to testify, and that can't be held against them. They can choose not to testify and call witnesses. They can choose not to do any of it. There's a possibility of a rebuttal case. In other words, prosecution calling other witnesses or producing other evidence to disprove something that the defense may have brought up. Closing statements. The survivor and any other witnesses can be present for that. Some of them like to see part of it. I usually recommend against seeing defense closings. Those can be very hard because obviously that's defense arguing that there are reasons that the survivor should not be believed. Listening to someone argue why you should not be believed can be very challenging. After that, there's deliberation and ultimately a verdict. That can take varying periods of time. If someone is convicted, either by plea or trial, in Maryland, the judge, not the jury, decides and delivers the sentence. There are sentencing guidelines that should be followed. The judge can, however, depart. These are guidelines, not strict requirements. They just have to explain why they're doing that. At sentencing, the victim has the statutory right to address the court. They can do that either by writing or by orally giving a victim impact statement. And that is something that we at SALI provide a lot of help with. And the court shall, by law, take that victim impact statement into consideration. Advocates can also help with drafting and preparing these statements, prompting people to think of certain things, helping if there's a language barrier, get that into English, things of that sort. So what do prosecutors' interactions with survivors generally look like? They might be done either by that ASA, that assistant state's attorney, or by someone called the victim witness coordinator, who is usually a social worker, not an attorney. They are never, to the best of my experience, an attorney. They're often social workers. And that usually begins with an initial interview or screening interview to help decide charges. If requested, there are forms that go out automatically with circuit court cases. They are required to notify the survivor of case status. It is very important if you're working with the survivor to verify if they've filled out that form, if the case is in circuit court. They can, again, if requested, to inform them about a potential plea bargain, to prepare a survivor to testify if it looks like it is going to go to trial. And then just one last reminder that there is no attorney-client privilege with anyone working for the state's attorney's office. So anything that the survivor tells anyone who works for that state's attorney's office, they're very likely going to have to tell the court and defense. So I know that we are running low on time and I was trying to go a little faster, which I didn't quite do. But please do feel free to reach out to SALI if you have questions yourself or if you have survivors who need legal help. I'm going to put my email in the chat box as well, and I'll stop sharing my.
Hi, everyone. I'm so sorry about my Wi-Fi struggles earlier. I think that we should be all set for the rest of today's presentation. We're now going into the SART panel portion of today's presentation. Before we get into that, I just want to briefly conclude the FNE role of the FNE presentation since I cut out right at the end there. Just to highlight one last slide, I just want to highlight evidence preservation. So that way we're all familiar, and then we'll go into our SART panel. So just to highlight very quickly, there are several things a survivor can do to best preserve evidence before getting a safe. So the first is not changing clothes is important because the survivor's clothes will be collected into evidence during the safe. If the survivor does change clothes, they should bring the clothes with them to the hospital. The next thing that I wanted to add is refraining from using the bathroom, refraining from eating, drinking, or brushing teeth, and then not showering or bathing beforehand. I do also want to finally highlight that if a survivor has done any of the previous listed activities, don't discourage them from getting a safe, as an FNE will still attempt to collect evidence. Just one last slide here. Here's contact info. I'm going to also put, before this presentation ends, my email in the chat. If you have any questions regarding the role of the FNE or anything regarding safes, you can feel free to reach out to me. I know that I was cutting in and out there a little bit, so I want to give you all the opportunity in case you missed anything. But we're now going to go into our SART panel where you have the opportunity to hear from an FNE. So hopefully any questions that you didn't get clarity on, she can provide as well. So I'm going to ask that all of our panelists turn on our camera, and Alyssa, our training and engagement specialist, will highlight all of you or spotlight all of you so you can be seen. So as I said, we're now going to go into our sexual assault response team panel. So for this portion of the presentation, we will hear directly from those who have the roles we just discussed, including a rape crisis center advocate, a law enforcement officer, a forensic nurse examiner, and a prosecutor. These individuals work on different levels, work on different sexual assault response teams throughout the state with different responsibilities to help pursue this interdisciplinary and victim-centered response. So before we begin, I just want to thank all of our panelists for joining us. We really appreciate you dedicating your time and your commitment to helping survivors. So I just wanted to emphasize that before we get started. I'm going to go into an introduction for each of our panelists so you all can get an idea of their experience and the type of work that they do, and then we'll go into questions. If you have any questions also that come up during the panel, you can feel free to put them in the chat. I'll address them as they come. I'm going to kind of have to balance our like predetermined questions with questions that come up. So if we don't get to your question, I will ensure to once again share my email so I can get a response for you from the panelists at a later date and contact you with that information. So to start off, for the role of the Rape Crisis Center advocate, we have Ashley. So Ashley is the Director for Advocacy Services at CASA, a dual domestic violence and sexual assault service provider in Washington County, Maryland. Ashley has over 5 years of experience in victim services with a background in education and psychology. Over the past 2 years, Ashley worked to expand the medical advocacy program offered throughout Washington County with a focus on training medical professionals to recognize and respond to domestic and sexual violence. So thank you so much, Ashley, for joining us today. For the role of the forensic nurse examiner, or the FNE, we have Christine Cooley. So Christine is the manager of the Domestic Violence Sexual Assault Center at the University of Maryland Capital Region Health Center. In addition, she assists with coordinating the forensic unit at the University of Maryland Aberdeen location. She is certified both as an adult, adolescent, and pediatric forensic nurse examiner. And in her 10 years as an FNE, she has completed over 1,000 exams and has been deemed an expert in multiple judicial systems, including strangulation, sexual assault, both pediatric and adult, alternate light source, human trafficking, and multiple other related topics. So thank you so much, Christine, for joining us today as well. Our next panelist for the role of the prosecutor from the state's attorney's office, we have Lindsay Carpenter. So Lindsay is the chief of special victims at the Frederick County Sheriff's Office. She received a bachelor's degree in criminal justice from the University of Maryland College Park and graduated summa cum laude from the University of Baltimore Law School. She's been a prosecutor since 2013, first working at the Baltimore County Attorney's Office and later transitioning to the Frederick County State's Attorney's Office. Finally, for the role of law enforcement officer, we have Lieutenant Josh McCauley, who is a member of Washington County Sheriff's Office. So during his 19-year career, he's had the opportunity to serve various roles, including uniformed patrol, canine handling, drug interdiction, crisis intervention, and criminal investigation, and he currently serves as the detective lieutenant managing criminal investigations unit at the digital investigations and forensic unit. So thank you all so much for joining us. Once again, we really, really appreciate your time and you willing to lend a hand of expertise to new professionals. So just to give a rundown of how questions will go, I'm going to ask a general question to each of our panelists. So for organization purposes, Christine, will start off with you. Then we'll go to Lindsay, and then we'll go to Josh, and then Ashley. Some of your questions are more specific to advocate work, so they're phrased a little differently, so I'll give that to you once they conclude with their responses. Also, since I have been having Wi-Fi troubles this morning, Grace is on standby to take over the panel, so if at any point I freeze, she'll pop in and take over, but hopefully we'll be fine. All right, so to start off, our first question is, what is important for a victim advocate to know about your role in the sexual assault response process? So Christine, we'll start with you.
Hi. I think one of the most important things for an advocate to understand is that a forensic nurse has to be non-biased and when we're speaking to victims. So the nurse, while we are advocates for their medical care and treatment, when we go to court and testify, we have to be able to say that is where the advocacy stops. So the advocate steps in. They're the warm and fuzzy person. They're the person that will get more of the situation as far as if they need counseling, hand holding, the emotional support piece. While nurses do give the emotional support to these victims, it's very important that we do establish a rapport with them. We really have to be able to speak when we testify that what we did while we were gathering evidence with the victim was not biased. So we're not really there to lead the evidence in one way or another. We basically will take the statement from the point in time that they were touched that they were uncomfortable with, unless there was a threat made or there was any type of weapon that was there. We will gather that data only. We try to really stick to only those points, not really gather a whole lot before what happened or after what happened. And then those statements lead our exam to collect evidence. So we don't collect evidence so that the victim will then go to court and get a positive outcome. We just collect evidence non-biasedly based on what they tell us happened to them. And it's very, very important that advocates understand that. So forensic nurses are not trying to be, not compassionate. But it's very important from the judicial standpoint that we are able to testify to that in court. So the evidence that we collect is basically based on their statement. It's not meant to lead to a prosecution one way or another.
Great, thank you so much. And then we did just have a question in the chat, if you don't mind. Somebody asked if they did shower and wash and changed, I'm sorry, if they did shower and wash and change, what is the process for collecting evidence, or are they skipping any processes if that occurs?
So I didn't hear exactly what was talked about prior to me getting on the phone, but a victim has 15 days to come and get an exam. And the reason for that is research shows that evidence-based research shows that we can get DNA evidence off the cervical os for really up to 28 days, but for 15 days, absolute. So that's the best area for us to get DNA evidence from. If a victim shows up and it's several days later, and they do talk about, their breast being licked, or, them sucking on their neck, or if they were strangled, we would still swab for epithelial cells, swab for saliva. We may not get that. But if a victim shows up 3 days later and they say they've showered, there's all different variations in cleanliness, right? So I'm still going to try and get evidence from that area. But the best bang for my buck is going to be when we do the inside, cervical swabs. But we would collect their clothes, and other things that are important as well to collect evidence from. And I think one of the most important things to remember is that we're not the only person that is going to make or break these cases. As we have different panelists here, because it's a progressive process. The detectives will also collect evidence from the scene. There'll be footage from cameras that were in the area. They'll interview witnesses. So the forensic nurses, while I feel our job is very important, it really is a small part of painting the picture when they go to court and the case is actually presented. Does that make sense?
Great, thank you so much. So Lindsay, we'll go to you. What is important for a victim advocate to know about your role in the sexual assault response process?
So my role is the criminal prosecution of the case. My office specifically is involved in the investigation very early on. We work closely with our forensic nurses as well as our detectives, and we're involved in the investigation pretty early on throughout that investigative process. Ultimately, we do decide whether or not criminal charges are appropriate for a case. We do that in conjunction with our investigators. We will, if a case is determined to be charged, we then use plea negotiations, of course, consulting with our victims and survivors, determining the best avenue to proceed with the case. We would engage in trial preparation with the victim. I think the other thing that's important to keep in mind as a victim advocate is, as I heard at the tail end of the last presentation, we actually represent the state of Maryland. So it's state of Maryland versus the offender. So we do not actually represent the victim or the survivor in the criminal proceeding. Certainly we are a voice for the victim and survivor as they are the victim in our case. However, we are not that individual's attorney. So I think that's important to know. There are victim rights attorneys that can be sought after and used by victims. We work very closely with them when we have them involved in our cases. But I do think it's important to distinguish that we are not representing the victim. We are representing the state of Maryland in the criminal proceeding.
Great, thank you so much. Josh, we will go to you.
So really, I think I just need to echo some of what Christine mentioned and Lindsay. So essentially, it's important, I think, for the advocates to know that we are fact finders above all else. I think that when a survivor initially contacts law enforcement, that process can probably seem a little bit cold. And understanding that at that initial point, there's so many factors in terms of jurisdiction, in terms of the elements of certain crimes, that that initial conversation does have to be a little bit more of a fact-finding, information gathering conversation. But also understand that that initial contact that you likely will have with a deputy or a police officer isn't the only contact that you'll have with law enforcement. A lot of times that initial response tends to be a little bit more of a triage. And then the case will travel to a more specialized investigator to follow up on. So like was mentioned, it is a little bit of a process. And there are certain things that have to be obtained information-wise to determine whether or not a case has, a crime has occurred and that certain elements of the crime have been met. But ultimately, those the deputies and officers are there to gather that information and proceed with the case and work for the victim.
Great, thank you so much. So Ashley, for you, how do you explain your role as an advocate to others in the response process or to the survivor?
Yeah, so I think, following along with all of that, what we really do as an advocate coming in is the easiest way to describe it is to be a support for that victim. As Christine said, we are there to provide that emotional support aspect throughout the exam. We're also there to make sure that the victim is aware of their rights. They're aware of what, if they are in charge of what they want to share, what processes they want to move forward with. We're also, I think what's important when working with other agencies is the understanding that we do hold that confidentiality. And so we are there specifically for the victim. Our role is not, the investigating or looking at the legal process. So we're there just for them. If they're sharing things with us, letting them know that stays confidential with us, that does not have to leave, our conversations. Caveat, all of this is outside of mandated reporting. I think I'll just throw that out there. So when we do work, with our local agencies here, that is something that we explain to them. So when working with other agencies, we're a support. We also maintain that confidentiality. And then when working with the victim directly, we're there, that could be advocating for them. If there's been times when, they're in the emergency room for a very long time and no one has come back, I can go in then and find, someone for them, get those answers to the questions for them, which they're not able to do. We help make phone calls for them. As simple as sitting and maybe we're watching TV, they, kind of whatever they need in that moment. That's what we're there for.
Thank you so much. So moving on to our next question, what should a victim advocate be able to explain to a survivor about your role in the sexual assault? Am I repeating the same question? No, I'm not. Okay. What should a victim advocate be able to explain to a survivor about your role in the sexual assault response process? So some things to touch on might be confidentiality, number of times interviewed, and mandated reporting. So Christine, we'll start with you.
Okay. So I think that it's important to know that everything that they say is not going to be necessarily confidential unless they are anonymous reporting and it's not mandatory. I know I have heard us touch base on that. You know, and I've actually had cases come in that a 14-year-old came in and she had snuck out in the middle of the night. Turned out after she told me the story that at the end of the assault, there was an exchange of money. That's human trafficking. So I had, you know, she knew going into it that we were mandated reporters. And while it started as a sexual assault, I then became a mandated reporter for human trafficking, right? Because there was an exchange of something, you know, of value. So I think that it's important to be, you know, realistic with your victims as far as confidentiality goes. I think that's really it. I think, you know, there's lots of important aspects. What question are we? We're on 3. I'm sorry because we went to 3 instead of 2. I think it's important for them to give realistic wait times. That's the other thing. You know, as far as victims coming in, every center is different. So at my center here in Prince George's County, we have advocates that are here all the time, 24 hours. During the day, they respond immediately. At night, it's a little bit of a lag time, but they come first and then they'll call the nurse. So there may be a delay. And I think it's important that victims that have already, you know, been through a trauma, that they understand how long of a wait they're going to be before the nurse gets there. And also it's important to let them know also how long the exam is going to take, and then kind of what the process is going to look like as far as if they get labs, if they get meds, you know, what their options are. That would be my take on that.
Sounds good. Thank you so much. So Lindsay, we can go to you.
So as I mentioned previously, I do not represent the survivor. So there is no attorney-client privilege. Everything that is disclosed to me or anyone who's part of my office or the forensic nurse or the investigator is all what we call discovery. So that is all disclosed to the defense. But on the flip side of that, I also think it's very important, and I always tell my survivors that it's so important to be honest. Even though there isn't that confidentiality, it's better to let me know what is going on. The defendant or the accused is going to certainly tell their attorney, and it's not helpful for us to be blindsided in trial. So while there is no confidentiality and while it is all part of the discovery process, I always tell my victim it's better to be honest and let me know everything that's going on. That way we can address it on the front end and not be surprised during trial. In terms of number of times interviewed, usually I leave that to the investigators. The only time that the prosecutor is typically interviewing the survivor about the actual facts of the case is if we are proceeding to trial. During that point in time, I will engage in trial preparation with the victim. I will need to discuss the allegations with the victim in preparation for trial. I usually prepare questions for the victim. I go through those questions so that the victim understands what questions are going to be asked of them in trial. Other than that, usually the only time that I'm really speaking with a victim about what occurred is maybe if there is a clarification needed, maybe a specific element of the crime I have a question about, and so I'll need to ask the victim about that one specific thing. But usually we are not interviewing the victim from start to finish of what occurred. We leave that to the investigators until it is time for trial preparation.
Great. Thank you so much, Lindsay. So Josh, we'll go to you.
So I think it would be important for a victim advocate to kind of help us manage expectations in terms of investigative timeframes. these investigations can unfortunately take quite a while. And there are circumstances where, an arrest can happen within, hours or days. But unfortunately, sometimes that arrest doesn't happen until we're able to receive, DNA results from a lab. Our current wait times for some of those results can be 6 months to a year, if not longer, in some cases, depending on the caseload of the lab. So helping us, like I said, manage those expectations with the survivor and letting them know that while we are waiting on these results, the case isn't necessarily stalled out, or work can still be done. And that it doesn't mean nothing is going to happen. We just have those, sometimes an extended time frame. Also, just touching on the interview portion that was kind of previously mentioned. I mentioned before that, the initial deputy or officer that comes out a lot of time is more of a triage as to where specifically this case should go. And so initially the survivor will probably give some type of statement to that initial officer, but likely later on when an investigator gets that case, the investigator may ask that the survivor come back in and provide, a more detailed account of the events, potentially audio and video recorded, trying to, go from the chaos that may have been that initial night to now a more calm interview where maybe some more information can be obtained. And if a second interview is requested, it's certainly not an indication of belief or not belief. It's just simply gathering that information that that initial deputy may or may not have gotten.
Great, thank you so much. And then also, we just got a question in the chat. I'm not sure if you or Lindsay would be best to answer this, but when it comes to fact finding, what's the minimum time frame you've seen when investigating a case?
Can I ask, just to clarify, time frame from what point? Would it be from, reporting to arrest, or, the incident occurring to when it's reported to the hospital or law enforcement? Clarify what time frame we're talking about?
We'll see if they respond in the chat.
Okay.
In the meantime, Ashley, we can go to you for your question, then we can revisit. So Ashley, for you, how do you explain your role of an advocate to, or I'm sorry, how do you explain the role of an FNE or a law enforcement officer or a prosecutor to a survivor?
So a lot of that is really just going along the lines of where we are there to make sure the victim knows what their rights are. If there's no mandated reporting involved, when they do disclose, abuse to an advocate, it does remain confidential if they do not wish to get law enforcement involved, if they don't wish to have an exam. So explaining that to them, but also I have found a lot of times talking to some of our survivors, when I explain to them, we have a forensic nurse department at our emergency department, and they are specialized in these cases. And a lot of times they've told me, well, if I knew this, then I would have come earlier. Then that was something I was told verbatim. So being able to explain to them the other services that are offered can be really helpful to make them feel more comfortable with the process. Legal processes are very intimidating. I think they can be very intimidating. So for us to be able to explain those processes to them, we've been able to have our advocate go to the state's attorney office, and they sit with the victim while they're being questioned, and that has helped them feel more supported. We do work very closely with law enforcement here in Washington County. Our legal advocates do, so that we, for having those relationships ourselves, we can make the victim feel more comfortable, if that's what they choose to do. And then on the other side of that, for us, it's also, explaining to them the safety planning aspect. So if you are going to make this report, do we need to do some safety planning on our end, whenever that person may be served or find out that you made the report. So that's another part of, being an advocate when we're explaining all the processes to them that we look at.
Great, thank you so much. And Josh, we got clarification in the chat. The question was regarding from receiving the case to court hearing.
So I think that's a difficult question to give a really solid answer on. It depends on a lot of variables. I have seen cases where an incident is reported and an arrest is made that same night just because of the circumstances that the responding officers were presented with at that time. They made that arrest. Once that arrest is made, it kind of starts the clock in terms of the court hearings. So if that subject was arrested on a felony charge, it could just be a matter of weeks until a preliminary hearing occurs in district court for those charges. If an investigation goes on for a month or two, or even longer if there's DNA, and that arrest doesn't occur until after that, and then you're looking at, again, weeks until a preliminary hearing and potentially months until a court hearing actually would take place. It could be, well in excess of a year before that case would actually see, the actual trial or resolution come through. So it really depends on, how the case plays out, when the arrest occurs, and what evidence that we're waiting on through that process.
Natalie, if I can just jump in real quick, I think also from the prosecution standpoint, once a case is charged, we typically tell our victims to not expect trial to occur for 6 months to a year. And that's just kind of a general. And that's from the point that the case is charged. Like the lieutenant said, any investigation, you could have a case that's reported and immediately charged, or we've had cases where we have to wait for the DNA to come back based on the circumstances of the case. And sometimes it takes 8 months to a year just for the DNA to come back because of the backlog in the labs. But I think a good rule of thumb is once the case is charged, if it's a felony, you're looking at 6 months to a year before there's a trial. Now, there's certainly going to be court hearings, plea negotiations, et cetera, but the trial date, I would say the first trial date will be about 6 months out.
Great, thank you both so much. So moving on to question 3. So this is from everyone or for everyone. So there's no advocate specific question for this. So from your perspective, what do you think is important for survivors to know about anonymous exams? So Christine, we'll start with you.
So, I always tell victims when they're trying to decide what they want, that anonymous is a great way to go. It allows me to get what I can't get later, right? So, we can get statements later, but we can't get evidence later. So that really is time sensitive. So it really is an important piece. So while you're deciding, people have a lot of understandable emotional, problems adjusting and things like that, fight or flight, that type of stuff, and they don't know what they want to do. Sometimes it's somebody they know or they feel responsible, but at least it allows us to get what we can't get later. What I do tell victims is that the thing that they may miss are the things that I discussed before. So it's important to know that if this really is a stranger and it happened in a bar, and you decide 12 months down the line, that video that was there, they're not going to be there. Photos maybe from people's cameras, they won't be able to gather that. Interviews with witnesses, they won't be able to gather that. So that is a consideration to think about when you're trying to decide, is this something that I really, don't want to move forward with right now? So they are the most important pieces to the anonymous explanation. The important aspect is that they do have 75 years. So when they are in an emotionally better place to move forward with this, they can then come forward, and you will have allowed us to get what we can't get later, right? We'll have that evidence that then they can, process through the crime lab and hopefully, get the matches that they would need, or the photographic documentation, because bruises are going to heal, tears are going to heal. All of that will have been captured in real time. So that's the best part of anonymous. But the other piece to remember is that there are other important pieces, because that we are not the entire investigation that may be lost by waiting, that additional year or 2 or 3 down the line.
Thank you. Lindsay, we'll go to you.
So I just kind of echo the same thing that Christine said. For me as a prosecutor, the most important thing is getting that forensic evidence if we can. Juries, especially with CSI nowadays, they want that forensic evidence. And so even if you're not ready or prepared to participate in the criminal justice process, if we can obtain whatever forensic evidence might be there, then we have that evidence for a later prosecution if the survivor decides to move forward with prosecution. I think it's also important too that while we can obtain statements later on, getting statements from the survivor right after the incident has occurred, there might be more details that are fresh in the survivor's mind. Certainly, we all know how trauma affects the brain, and that sometimes there may be jumbled up memories, but trying to get as many details as possible at the initial time. And then later when the survivor wants to report it, we can go back and there might be some information from that anonymous report that the survivor later forgot about when they decide to report to law enforcement. So I think the most important thing to know is that it's giving the survivor a chance to collect that important forensic evidence for use later in a trial, even if they're not prepared to proceed in the criminal justice process.
Great, thank you so much. We also got a question in the chat before moving on. So does the state's attorney's office facilitate any trauma-informed lawyering training for staff working on these cases?
So I will say that all of our, so there's only 2 attorneys in my unit right now, myself and another prosecutor. We attend trainings that are put on by the National District Attorneys Association. We've attended trainings put on by MCASA. We also have trainings put on by the Maryland State's Attorneys Association. I will say I can't speak for every single state's attorney's office. I can only speak for my state's attorney's office. Even though we represent the state of Maryland and we are not the survivor's attorney, we operate in a very victim-centered manner in terms of I may have a case that I believe is prosecutable, but it's a borderline case and it may be a difficult case. In those circumstances, I will ask the victim or survivor to come in and meet with me, and I will explain to them what the criminal justice process looks like. And I will explain to them that I believe them. I believe the case is prosecutable, but this is what the process is going to look at so that they can make an informed and educated decision as to whether or not they feel as though they can participate in that process. Same with plea negotiations. I will always sit down and speak with a survivor and explain to them, what our case looks like, what the strengths are, what a trial looks like, and talk about what justice feels like to that particular survivor, and before I relay any plea offers. So like I said, I can't talk generally about state's attorney's offices in Maryland, but I can talk to what our office does in terms of victim-centered prosecutions.
Thank you so much. Josh, we'll go to you. So from your perspective, what do you think is important for a survivor to know about anonymous exams?
I think I really just have to echo a lot of what everybody else said. I'll add that, if anonymous, we take that very seriously. We take the survivor's anonymity very seriously. So if anybody that you're working with is concerned that we're going to do digging into this and look into it against their will or without their consent, that's not the case. An anonymous case for us is anonymous until we get word from the survivor that they're ready to go forward, and then we jump into it. Now, that said, again, echoing what everybody else said, the SAFE exam and even the initial statement is only one part of that investigative process. Witnesses move away and forget, and DNA evidence at the scene of a crime will deteriorate or become destroyed. So the sooner that we're able to jump into that investigation, the higher the likelihood that we're able to obtain more supporting evidence that would then make that legal process that Lindsay was talking about maybe a little bit easier and maybe a higher likelihood of a plea agreement or something that maybe wouldn't expose the survivor, to as much, secondary trauma, that type of thing. So the faster that we can get into that, the better. But if they're not in a place right now for that, anonymous does mean anonymous, and we won't dig until we get that permission from the victim.
And can I say one more thing? I think it's important for them to know also that these kits will not be tested. So I have had victims say, "So when will I get the results of the test?" And I'm like, "No, you have to understand that, anonymous means anonymous. It stays sealed and it is put somewhere for 75 years and not processed until you move forward. The name on the front says anonymous. No one will know what's inside. No one will read your statement that you gave me. This will not get touched until you decide to move forward." And I think that does cause some confusion because, the CSI and people watch that stuff on TV. So they think it's going to get processed anyway. But I think that's an important piece to also mention.
Thank you both so much. Ashley, we'll go to you. So from your perspective, what do you think is important for survivors to know about anonymous exams?
Yeah, well, I think everything, said is very important. So just as kind of a follow-up, make that they know that that's an option and that they understand the parameters, like Josh was saying, as far as that is anonymous, that, that is something that is going to remain anonymous until they're ready to report. And, just in my mind, as everyone's talking about this, and from the advocate standpoint, a lot of times we go back to safety. And so for me, what's coming to mind, as a practical example is a lot of times, with that intersection of sexual assault and intimate partner violence, maybe it was a sexual assault within an intimate partnership and they don't feel safe at the time to report, but knowing that they can get the exam done still and that it can be kept anonymously, that's kind of a practical situation where that could be really helpful for a survivor to know that this is available and to understand all of the parameters that everyone else has shared.
Great, thank you so much. So moving on, this question is also for all of you. In your opinion, what do you consider to be the most beneficial aspect of a sexual assault response team for both your profession and organization and also for survivors? So Christine, we'll start with you.
So I think this is an accumulation of what the benefit is, right? Because it's all of us coming together, keeping the victim in the center and trying to figure out how we can work together, bringing all of our unique aspects together to then, to not only, collect the DNA evidence, but to work together for all the other pieces, right? Because I'm just a piece of the puzzle. And so, my training I can use to train the state's attorney in strangulation and the detectives in strangulation. And they can come and train, our center with their areas of expertise, what happens behind the scenes with the detectives and with cases. And this speaks to why it's so important for us all to work together in that aspect. That's the most important piece to me, is that we all work together for the same outcome.
Thank you so much, Lindsay. We'll go to you.
So I would echo, I think collaboration is the key in all of these cases, working together from the beginning so that we can all input our knowledge and our expertise to make the case the best possible case that we can on behalf of the survivor. Each of us professionals have a different piece of information regarding the investigation, and by all of us working together, we're able to put that all together. I think it helps us fill in the gaps. It makes a stronger case, which would lead to more likely successful prosecution. I mean, I speak with my forensic nurses all the time, investigators all the time, and we start from the moment that the case is reported. So we're working this case together and sharing all those different pieces of information. I think it's also helpful to the survivor because it also limits the amount of times that the survivor needs to share their story. So by the forensic nurse speaking with with the investigator about what was learned, or better yet, the investigator being there during that forensic nurse's interview, we're limiting the amount of times that the victim or survivor has to be interviewed, and we're collaborating and pulling that information together. So by us working as a team, it's more beneficial to the survivor, both through the investigation and a better potential outcome for successful prosecution.
Great. Thank you so much, Lindsay. Josh, we'll go to you.
Again, I think everyone has covered it pretty well. I'll add, I think that one of the main benefits, at least from a law enforcement perspective, is the accountability. I think that it's easy in law enforcement, I'm sure in all of the other the specialties here as well, for the new cases to come in and everybody to get bogged down with different cases and different things that are going on. And having this opportunity to come together and focus on this specific type of case and answer questions about a case provides a needed accountability to make sure that these cases are progressing for the survivors. And that, like everybody mentioned, the brainstorming, the 2 heads are better than 1 and 6 are better than 2. So everybody coming together and having those resources. I also think it's important that the establishment of the relationships that we have with people on the team, knowing that I can be out on a scene and I have the contact information for the forensic nurses in my county because I work with them and know them from the SART meetings, and being able to call them and say, hey, this is what I have. What do you think? Can you explain this to me? Being able to talk to the specific prosecutor that is assigned to those types of cases within my county. Again, all of that is invaluable. And even having the advocates, I can't possibly remember or know all of the resources that are available in a given area or in the next county over where a victim may reside. So having those people that I can reach out to right now in the active portion of investigation, those relationships were established as a result of this. So it's been a really important process and has helped numerous cases.
Great. Thank you so much. Ashley, we'll hand it over to you.
Yeah. So I just always say none of us can do this on our own. I think the benefits of collaborating and having relationships with the other agencies and other service providers in your county is immeasurable. Here we do have a very close relationship with our forensic nurse department. We are just now moving in to have a CASA Inc. staff member stationed at the emergency department full time. And taking on case advocacy for the patients who come in and that fall under CASA's services full time. So we also have put in, we now have a connection with the forensic nurses where if someone calls into our hotline, we can conference them in with a forensic nurse. That is already led to some persons going to get medical care when they had called in originally. That was not in their plan. I've seen over the last 2 years, really, we've expanded, done a lot of training with the emergency department. We work very, very closely with forensic nurses, and it was a very, very significant increase in the number of persons who went for an exam who then came in for services. So being able to foster these relationships and being able to work collaboratively, here in our Washington County, in our small little area here, we have seen the benefits where these survivors are getting more services, more medical care. We're able to help them feel more comfortable to collaborate with law enforcement and with the legal processes. So really it's just immeasurable. And I don't believe we can do these jobs without relying, using each other's expertise and services.
Thank you so much. I think all of your responses really highlighted how important it is for this interdisciplinary response and how, in order to offer the best care possible to survivors, how important it is for sexual assault response teams to work together. And each of your individual roles are so important. So, once again, I want to thank you all so much for your time. We really, really appreciate it. Being able to lend your expertise is invaluable. So, thank you so much again. I am going to once again put my email in the chat in case anyone has any questions for our panelists in the future, and you'd like to connect with them. I can connect you or get whatever question you have answered. I think Alyssa just put the evaluation in the chat as well, so I will hand it back to her to conclude the training.
Thank you, Natalie, and thank you to all of our panelists and presenters today. As Natalie said, I just put the evaluation link into the chat. We greatly appreciate all feedback as we're constantly striving to improve. Additionally, if you're seeking a certificate of attendance or a certificate for CEU credits, you must complete the evaluation form. Upon submitting the evaluation form, you'll see a box at the top of your webpage containing a link. And if you click on that link, you'll be able to access the CEU request form. If you have any questions, feel free to email me. I'll be sending out a follow-up email later today with the PowerPoints used in today's presentation, as well as a copy of today's recording. Thank you again for being here, and we look forward to seeing you tomorrow.